Good morning, everyone. This is the time and forum noted for hearing in the matter of the application of Rocky Mountain Power for approval to enter into resource contracts in excess of 15 years. That's Commission Docket number 20-035-37. My name is Michael Hammer, and I am the Commission's designated presiding officer for this hearing. Let's go ahead and take appearances, beginning with Rocky Mountain Power, please. No one's on the line? Oh, we can't hear you, Emily. I can't.
Because I'm double. Yep, because I'm double muted. Can you hear me now?
Yes.
Okay, good deal. Emily Wegener, appearing on behalf of Rocky Mountain Power, and I have with me Kyle Moore for the company.
Thank you. And for the Division of Public Utilities?
Good morning, Patricia E. Schmid for the division. With me as our witness today is David Williams.
For the Office of Consumer Services?
This is Robert Moore, Assistant Attorney General, representing the Office of Consumer Services. Our witness today will be Bela Vastad.
And I see some other parties are on the line. You're welcome to listen. Would you like to enter an appearance today?
This is Gary Dodge. We have not intervened. I represent Salt Lake City and Park City. I'm on the line, but I don't need to enter a formal appearance. So thank you.
All right, thank you. Then we'll begin with Ms. Wegener. Are you ready to call your first witness?
I am. The company calls Kyle Moore.
Mr. Moore, do you swear to tell the truth?
Yes.
Go ahead.
Good morning. Can you please state your name and business address for the record?
Yes, my name is Kyle Moore, and I work at 1407 West, North Temple, Salt Lake City, Utah, 84116.
And what's your position at Rocky Mountain Power?
I am a power marketer / originator in Rocky Mountain Power.
Did you prepare and submit testimony in docket number 20-3537 on August 20th,
Yes,
2020?
Yes.
Do you have any corrections to that testimony?
No.
If I asked you the same questions that are in your pre-filed testimony today, would your answers be the same?
Yes.
I move to admit the testimony of Kyle Moore.
It's admitted.
Could you please provide a summary of your testimony?
Yes. On August 18th, 2020, Rocky Mountain Power filed an application together with pre-filed testimony and exhibits requesting approval to enter into certain contracts for resources to serve Salt Lake City, Park City, Summit County, Utah, Utah Valley University, Vail Resorts, and Deer Valley Resorts, collectively customers, under Electricity Service Schedule 34 that extend beyond the 15-year term for commission-approved avoided cost prices. As the company explained in its application, there are extenuating circumstances that require power purchase agreements, terms of 20 and 25 years, with corresponding longer-term avoided cost pricing for the customers. Schedule 34 states that the rates paid by the customers will include an incremental charge that incorporates the concept of avoided costs as defined in Utah Code Annotated Section 54-2-1, Section 1. To determine the incremental charge, the customer contracts use the term resource avoided cost, which the contract defines as an amount in dollars per kilowatt hour based on the company's Utah Electric Service Schedule 38, applicable as of the date of determination, equivalent to the levelized avoided cost purchase price that would be payable to the owner of a qualifying facility, as defined in such Schedule 38, with a size, location, and fuel source comparable to that of the relevant customer renewable resource. Schedule 38 currently limits a qualifying facility's contract term to 15 years. Schedule 34 does not specify a minimum or maximum resource contract term. In docket number 18, I apologize. I think that I had some edits here that I did not accept. Rocky Mountain Power, the Division of Public Utilities, and the Office of Consumer Services, collectively the parties, entered into a settlement stipulation filed with the Commission on October 20th, 2020, in which the parties recognized that the extenuating circumstances relating to the ongoing COVID-19 public health emergency and its related effects on the economy and the PPA contract with the Schedule 34 resource specifically are key factors that allowed the parties to agree to the stipulation. The parties agree that the extenuating circumstance provide a reasonable and rational basis for a one-time approval of a longer term that is inconsistent with the 15-year term initially negotiated and with the maximum terms of Schedule 37 and 38 contracts. The parties agree that nothing in the stipulation is to be construed as binding or used as precedent in future cases before the Commission. Based on the application and the stipulation, the proposed avoided cost treatment complies with the requirements of Schedule 34 and are in the public interest, and the company respectfully requests that they be approved by the Commission.
Thank you. I have nothing further, and this witness is now available for cross-examination.
Ms. Schmidt,
No questions?
Mr. Moore,
The office has no questions. Thank you.
and Ms. Wegner, do you have any other witnesses?
I do not.
Okay, I have nothing for you, Mr. Moore, so we'll go ahead to move on to the next witness.
Good morning. This is Tricia Schmid with the Division of Public Utilities. Our
Pardon me.
witness is
Pardon me, Ms. Schmidt. I thought I heard Ms. Wegner say I do. You have no other witnesses. So
No, I said I do not. I apologize.
I didn't get the not. Thank you. I'm sorry. Go ahead, Ms. Schmidt.
Good morning. This is Patricia Schmid with the Utah Attorney General's Office. Our witness is David Williams. May he please be sworn.
Mr. Williams, do you swear to tell the truth?
I do.
By whom are you? Please state your full name for the record.
David Williams.
By whom are you employed and in what capacity?
I'm a utility analyst with the Utah Division of Public Utilities.
In conjunction with your employment by the division, have you participated in this docket?
Yes.
Please describe your participation in this docket on behalf of the division.
I have reviewed the testimony and participated in the settlement discussions among the parties.
Do you have the division's position to share with us today?
Yes.
Could you please present that?
Yes, the division supports the stipulation and requests that the commission approve it as filed. The company has provided a description of the facts leading to the stipulation. I will summarize the key points that underlie the division's recommendation. Under the Schedule 34 conditions of service, the customer pays rates comprised of three parts: the normal tariff rate, cost-based administrative fee, and a third component. And for this third component, unless the commission approves a different method, the third component is, quote, an incremental charge equal to the difference between the cost to the company to supply renewable generation to the customer and the company's avoided costs as defined in Utah Code Annotated Section 54-2-1, Section 1. Avoided costs for qualifying facilities are addressed in Schedule 38, and the contracts that the company has with the customers in the present case use the term resource avoided cost, which in turn is defined in terms of Schedule 38. Schedule 38 limits a qualifying facility's contract term to 15 years. Therefore, although Schedule 34 itself does not specify the allowed length of a contract term, a PPA contract term longer than 15 years is not contemplated by Schedule 38. Extenuating circumstances in this case prompt the division to support the settlement. Of particular import to the division, The company negotiated with the customers for a 15-year PPA, but COVID has had an effect on the financing market, and 15-year financing was not available. Therefore, the division agrees that a one-time approval of a PPA term longer than 15 years is appropriate in this case. As mentioned by the company, the parties agree that nothing in the stipulation is to be used as precedent.
Thank you, Mr. Williams. Does that conclude your comments?
No, I had a little bit more, sorry.
Okay, please continue.
As far as adjustments to Schedule 34, Schedule 34 may be modified to avoid future issues similar to this one. The parties agreed to meet in 2021 to discuss changes to the tariff. We do not yet know exactly what these changes would look like, but we will consider input from interested parties. So in conclusion, one-time approval as set forth in the stipulation of this PPA longer than 15 years is just, reasonable, and in the public interest. This concludes my summary.
Thank you. Mr. Williams is now available for cross-examination questions and questions from the hearing officer.
Ms. Wegener?
No questions. Thank you.
Mr. Moore?
No questions. Thank you.
And I have nothing for you, Mr. Williams. Thank you.
Thank you.
Ms. Schmidt, any other witnesses?
The division has no other witnesses. Thank you.
Thanks. Go to you, Mr. Moore.
The OCS called Bela Vastag and asked that he be sworn.
Mr. Vastag, do you swear to tell the truth?
Yes, I do.
Thank you.
Could you please state and spell your name for the record?
Yes, my name is Bela Vastag. That's B-E-L-A. Last name Vastag, V like in Victor, A-S-T-A-G.
How are you employed and what is your business address?
I am employed by the Office of Consumer Services as a utility analyst, and our business address is 160 East, 300 South, Salt Lake City, Utah.
In your capacity as utility analyst for the OCS, have you participated in negotiations and drafting of the settlement stipulation that is the subject of the hearing today?
Yes, I have.
In your opinion, is the settlement just and reasonable and result in the public interest?
Yes.
Have you prepared a summary of the OCS position
Yes, I have.
on the settlement? Please proceed.
Good morning, Mr. Hammer and the other parties at today's hearing. For some background, on February 6, 2020, in a separate proceeding, in docket number 19-035-39, the Commission approved Schedule 34 contracts between Rocky Mountain Power, or RMP, and several large RMP electric customers. These customers are Salt Lake City, Park City, Summit County, Utah Valley University, Vail Resorts, and Deer Valley Resorts. Collectively, these Schedule 34 contracts are referred to in this proceeding and in the stipulation as the customer contracts. Just again, background, the purpose of Schedule 34 is to allow Rocky Mountain Power to purchase renewable energy for certain qualified customers. The customer contracts are not directly at issue in this proceeding. What is at issue is the contract, or in other words, the power purchase agreement, or PPA, that RMP has signed for the renewable resource that will provide the renewable energy that is required under the customer contracts. The issue that Rocky Mountain Power has raised in this proceeding is that when the Commission approved the customer contracts back in February of 2020, Rocky Mountain Power stated that the renewable resource PPA would be for a term of 15 years. But now RMP states that the PPA term must be greater than 15 years. Rocky Mountain Power explains that the increase in the PPA term is needed so that the project developer can obtain financing to build the customer's chosen renewable resource. This change in PPA term length raises some important questions about how to calculate the avoided cost to be used in the customer contracts, including how to handle the fact that current avoided costs are now higher than those calculated when the initial, or now lower, sorry, than those calculated in the initial PPA, when the initial PPA was negotiated and when the customer contracts were signed. After we reviewed the customer contracts and our Rocky Mountain Power's filing in this proceeding, and then after some discussions with Rocky Mountain Power and the customers, the Office of Consumer Services, or OCS, identified two primary issues resulting from RMP's request to change the PPA term length in this proceeding. One, whether it is appropriate to use avoided costs based on a combination of the original 15-year PPA and the new longer-term PPA for pricing in the customer contracts. And two, that Schedule 34, as currently written, does not contain enough specific information on how pricing and other procedures are to be implemented when RMP develops customer contracts and negotiates PPAs with the associated renewable resources. The OCS believes that resolving these two issues is very important to ensuring that RMP customers who do not participate in Schedule 34 do not bear any additional costs associated with Rocky Mountain Power acquiring a Schedule 34 resource, or with Rocky Mountain Power providing service to these Schedule 34 customers. However, the OCS does acknowledge that the current COVID-19 public health and then the related economic crisis have created extenuating circumstances, making it difficult for RMP to finalize the Schedule 34 customer contracts and the associated PPA with the customer's chosen renewable resource. Therefore, the OCS does not oppose Rocky Mountain Power's proposed terms in this proceeding under these specific and limited circumstances. The OCS wants to make it clear that the stipulation does not set a precedent for how Schedule 34 pricing is to be determined in future contracts that RMP enters into under different circumstances. However, the stipulation does provide for the finalization of the customer contracts and the resource PPA at issue in this docket. And importantly, the stipulation also provides for a process to reform and improve the Schedule 34 tariff in a future proceeding. The OCS participated in several settlement negotiation meetings and was very involved in the development of the stipulation now before the Commission. The OCS appreciates how the parties have worked together to develop a stipulation that will allow the Schedule 34 customers to move utilize more renewable energy, and also includes an agreement for parties to collaborate to improve how Schedule 34 is implemented in the future. The OCS believes that this settlement stipulation is just and reasonable in result and in the public interest. The OCS recommends that the Commission approve it. That concludes my statement.
Mr. Vastag is available for cross-examination and questions from the hearing officer.
Ms. Wegener?
No questions. Thank you.
Ms. Schmidt?
No questions. Thank you.
And I have nothing for you, Mr. Vostok. Thank you for your testimony. Anything else, Mr. Moore?
The office has no further witnesses.
Okay. Is there anything else that we need to address before we adjourn? All right. Thank you, everyone, for your participation. Take care. We're adjourned.
Thank you.
Thank you.